Namaste and welcome back to ICEP iLUNO, your channel for constitutional insights and legal literacy. Today, we are diving into the powerful trio Articles 20, 21, and 21A of the Indian Constitution. These provisions are the pillars of justice, dignity, and human rights in India. So let's decode them clearly, concisely, and constitutionally. Let's begin. Section 1. Article 20. Article 20 protects individuals from arbitrary and retrospective punishment. It covers three core principles. Small diamond, no ex post facto laws. You can't be punished for an act that wasn't a crime when you did it. Small diamond, no double jeopardy. You can't be tried twice for the same offense. Small diamond, no self-incrimination. You can't be forced to testify against yourself. Case laws to know. Kedarnath v. State of West Bengal, no retrospective punishment. Salvi v. State of Karnataka, narco analysis violates self-incrimination rights. But there's a dark side too, misuse of preventive detention laws like UAPA and NSA. These test the limits of Article 20 every day.
Section 2, Article 21, next, Article 21, the heart of the Constitution. It simply says, no person shall be deprived of life or personal liberty except according to procedure established by law. Sounds simple? Well, it's one of the most interpreted provisions in Indian constitutional history. Expansions through case law, Menka Gandhi v. Union of India procedure must be just, fair, and reasonable. Puttaswamy v. Union of India right to privacy is a fundamental right. Olga Tully's right to livelihood is part of the right to life. MC Mehta right to a clean environment. Common cause right to die with dignity. Article 21 has grown to include digital rights, environmental justice, health, education and much more. But modern threats like custodial deaths, internet shutdowns, and surveillance continue to haunt its spirit. Section 3, Article 21A. Introduced by the 86th Constitutional Amendment, Article 21A made education a fundamental right for children aged 6 to 14. It gave rise to the Right to Education Act, 2009, which mandates free and compulsory education 25% EWS quota in private unaided schools. Key cases. Mohini Jain first recognized education as a fundamental right. Unni Krishnan right to education up to age 14. Pramti Educational Trust RTE doesn't apply to minority institutions. However, high dropout rates, poor infrastructure, and unequal access still pose serious implementation challenges.
Section 4. Judicial interpretation. Initially, courts followed a narrow reading like in the A.K. Gopalan case. But post-Menka Gandhi, we've seen a rights-expanding interpretation of Articles 20 and 21. Today, the judiciary uses literal interpretation, harmonious construction, expansive interpretation, adding socio-economic rights like education, health, dignity. Conclusion. To conclude, Articles 20, 21, and 21A represent India's deepest commitment to justice and human dignity. They have grown with time, through the strength of our judiciary and public activism. But rights must always be guarded against state overreach, poor implementation, and social apathy.
If you found this video helpful, don't forget to like, share, and subscribe to ICEP iLUNO. Comment below with your thoughts and let us know which article you'd like us to cover next. Thank you for watching. Jai Hind.